Congratulations, you've been summoned for jury duty. Now, if it was the 1990s and a popular sitcom, it's likely that there are a lot of groans and moans. But nowadays, people hope that they can get on a jury, especially in high profile cases. But in general, jury duty is basically society's least exciting lottery. You don't win money, but you do get $50 a day and a chance to judge strangers. And in America, judging strangers is a national pastime. So who can serve on a jury? In the US, jurors have to be 18 years old, they have to understand English, and they have to be able to physically sit through a trial without complaining too much. Some professions get automatically excluded, like most criminal justice professions or anyone who might have a bias. I've always wanted to serve on a jury, but one, I've been in school for too long, and so that usually gets me out of it. But two, I'm a criminal justice professor, so I'm generally going to be biased because I do research for the system. Although I can be unbiased and I just want to be on a jury, but maybe someday what'll happen. Anyway, fun fact, in Colorado, people who have felony records can serve on trial juries, but not on grand juries. So yeah, rehabilitation can come with a side of civic duty. In Colorado, potential jurors are chosen from a local population using a computerized system that randomly pulls names from things like voter registration lists, driver's licenses, and state ID records. The state court administrator makes sure the process is fair by prioritizing people who hadn't recently served. So if you've already done your time for jury duty purgatory, you get a short break before they summons you again, hopefully. But sometimes it is random, so you may get called for jury duty twice in a short period of time. But for the most part, Colorado tries to prioritize people who haven't served on a jury. So if your name comes up from the grand computer raffle, you'll get a jury summons in the mail. It tells you when and where to show up, and no, pretending like you never checked your mailbox doesn't make it go away. There are a few legitimate excuses people can offer to get out of jury. A lot of it is severe hardship, like just sitting in this trial is really going to make things harder for someone in their personal life. Maybe they are taking care of an elderly or a sick person. Others could be medical incapacity. They can't sit through the whole trial, or they're going to have surgery, or there's some type of medical issue that would make it hard for them to participate. And then there's other caregiving responsibilities. But for the most part, people need to report. Think of it as your once a year reminder that democracy isn't free. It costs $1.05. Well, I mean, it costs more of a morning, maybe an awkward conversation with your boss, and a few hours sitting in a courtroom wondering if they have decent Wi-Fi. But Dr. Brady, I have to work. I can't get out of my job. Well, the good news is that employers cannot fire, threaten, harass, or penalize you for being summoned for serving on a jury. It's random, so it's not your fault. Your name came up, and it's a civic duty. And your employer cannot fire you or demote you. It's actually illegal retaliation to discipline or even terminate someone for missing work because they were serving on a jury. And what's interesting is you also may not be out of a paycheck because in Colorado, the payment responsibilities are split between your employers and the state, depending on how long you serve. So in Colorado, for the first 3 days of jury service, your employer must pay you your wages or your average daily wage for up to 3 days of jury service. This applies to both full and part-time employees, except for self-employed folks. You are not reimbursed. You're expected to cover your own time. So, for example, if you are called for 1 day trial, your employer will just keep your pay as is or pay you like it's a normal day. If you're still on a jury by day 4, that's where the state comes in and they will start to pay you $50 a day. But then if you're in like some high profile murder crime where it's going to be 4 or 5 weeks, $50 a day, I mean, to some it might be not bad, but for others, you're rich. So just because you get summoned for jury duty does not mean that you're actually going to serve on a jury, because we have to make sure that the people that are summoned can be unbiased. And so this is where we have a vetting process where we essentially weed out people who have those hardships, can't serve on the jury, or are just straight up unbiased, or in some cases give the attorneys a weird vibe and they don't want them on the jury. So the process starts with what we call veneers, not like the teeth. It's a fancy Latin term for randomly selected group of mildly annoyed citizens. It's supposed to represent a fair cross-section of the community. And then from there, we move to voir dire, which can be pronounced voir dire or voir dire, depending on how pretentious you feel that day. During voir dire, the judge and the attorneys will ask potential jurors questions regarding their background, their beliefs, and whether they can be impartial. And they're basically trying to figure out if the juror can fairly decide a case, or if they're secretly trying to send everyone to prison because you have that one bad roommate. During your voir dire, you'll get asked questions like, what do you do for work? Ever been arrested? Can you be impartial? Would you sentence someone to death? It's kind of like speed dating, but the goal is to find people who can fairly decide whether someone should go to prison, not whether they're like dogs. So the weeding out process occurs in two ways. And so attorneys on both sides, the prosecution and the defense, what we call challenges for cause and peremptory challenges. These are the ways that attorneys can get people off the jury. So the first is when a juror is excluded for cause. Challenges for cause occur because there's a legitimate reason as to why they can't serve on the jury or why they can't be impartial. This is generally because the juror believes and is adamant that they just really can't be unbiased in this case. For example, say you have a retired police officer in a case about an assault on a police officer. The lawyer can ask the judge to excuse them for cause because they're former law enforcement. And if the officer argues that it would be really hard for me to be unbiased in this case, that could be a challenge for cause because there's a legitimate reason as to why this person can't be unbiased. Other times I've seen mothers who have had kids who are addicted to substances and have broken their house, stole their purse, and punched them in the face, meth, not even once. And so sometimes they will say it's really hard to be unbiased in this situation because it's affected me personally. Or sometimes you have survivors of a particular type of crime that get called for jury duty, and it's just too traumatic. They can't really sit through the trial, and it's hard for them to be objective, especially when the person is being charged with similar things that happened to them. There's no limits or how many challenges for cause each side gets, because we want juries to be unbiased as possible. So if there's a legitimate reason as to why someone can't be unbiased, then the attorneys can do a challenge for cause, and then that excuses that juror. The second option is peremptory challenges, which let attorneys remove potential jurors without giving a reason, as long as it's not based on race, gender, or ethnicity. So each side gets a limited number of these. Maybe the attorney doesn't like how you crossed your arms. Maybe you wore a shirt that says Free Jeffrey Dahmer. Either way, you're out. And they don't have to provide a reason for exclusion. The only reason why they can't use a peremptory challenge is if they are trying to decide based off race, gender, or ethnicity. This can be where it gets tricky because unlike challenges for cause, which there has to be a reason as to why they're getting removed from the jury pool, the peremptory challenges, all the attorney just has to say is like, we would like to excuse juror 11, and they don't have to give a reason as to why. However, the other side may be suspicious that the other side is excluding jurors based off of race or gender. And that is a big no-no, according to the Supreme Court, Batson v. Kentucky, 1986. Because shockingly, that was a problem. So lawyers in Colorado, they get about 3 peremptory challenges for misdemeanors and 5 to 10 for felonies. So most of the reasons why they are vetting people out should be challenges for cause because those are unlimited, but they do get a handful of challenges where they can get a jury removed and they really don't have to explain why. So if you make the final cut, congratulations, you're officially a juror. You'll get the trial date, you'll sit through the case and deliberate with your fellow jurors to reach a verdict. If you don't get picked, you're free to go and your civic duty is officially complete. You'll still get paid for showing up, and you can brag that you almost made it on a jury, which is a great story to tell exactly once. And in sum, jury duty may not be glamorous, but it's one of the few times ordinary people hold real power in the justice system. You get to weigh the evidence, interpret facts, and decide the outcomes, all without having to pass a bar exam. Sounds pretty good. So the next time you get that summons, don't groan too loudly. It's not a punishment. It's proof that the system still needs people like you or a cat named Sal Esposito. Yes, that actually happened. The cat was summoned for jury duty. Turns out he was perfectly impartial. I'm going to stop talking now.